Good afternoon. Calling the next case, Childers versus Progressive Marathon Insurance Company. Just double checking here. That is, looks like we have 20 minutes per side. Is that correct? Okay, great. You may reserve time for rebuttal, but we ask that you keep track of that. And you may
Yes.
begin when you're ready.
Thank you very much, Your Honor. Excuse me, Daniel Saylor appearing on behalf of the defendant appellant, Progressive, and I would like to do my best to save, let's say, 3 minutes for my rebuttal. So to start, I want to make an introductory comment that applies to both issues. We essentially have two. And I just want to lay the groundwork by reminding the court that the MPGCA, the association, its principal role here, its principal reason for existence is to protect insured claimants, not to save money, okay? They assume that the association assumes claims that were being paid by the insurer, and, which then becomes insolvent. And in order to protect these injured claimants, the guarantee association steps in and assumes responsibility for these covered claims, a statutory term referencing those claims owned by the injured person and being paid by the insolvent insurer. Those are covered claims. And so the default position then is that the association takes over and handles those covered claims. Now, true, if the injured person here, Childers, has other coverage for the loss and benefits are still recoverable under that coverage, then those benefits are automatically higher in priority than the association's benefits. So there's two issues here, and these are those that are arising in this case. Is there any other coverage? The contention is that Progressive qualifies as other coverage. And secondly, if so, are benefits under that coverage recoverable by Childers? The first issue is the coverage issue, which I want to only touch on very briefly, and I'll come back to if I can, but I want to get to the limitation of actions issue. But the first issue, of course, is our contention is that Childers' injury claim is not and never was a loss covered by Progressive. We know that the issue is presented under subsection 4, section 3114.4 of the No-Fault Act as it existed then, which requires for there to be coverage, the insurer has to be the insurer of, in this case, Shana Gruels. But she had no insurer. Progressive was not her insurer. She was uninsured and her car was uninsured. Here, and it turns on whether the insurance company assumed any risk to pay her losses, to protect her from loss, from her liabilities, and so on. And here, Shana Risk had no protection, no coverage, was assumed, no coverage assumed by Progressive for her. And I will come back to that, but the bottom line is that Progressive did not qualify as her insurer. On the limitation of actions issue, even if Progressive was in the order of priorities, benefits were not recoverable by the claimant, Childers. And so the association, under the credit provision 7931.3, the association has no credit against the Childers covered claim, and it has no viable reimbursement claim for benefits that it had already paid because Childers had no viable claim to assign to the association, and that's under 7935.2. I want to read two stipulated facts from the case. I happened to look them over, and numbers 7 and 8 pretty much make my argument on this question of limitations of actions, and these are stipulated by the parties. Number 7, pursuant to the statutory duties of the association, and subject to any rights and limitations in the Act, the association, quote, became responsible for the insolvent insurer's obligations that qualify as, quote, covered claims within the meaning of Section 7925, and Justin Childers' claim for PIP benefits against American Fellowship qualifies as a covered claim. Now, that's a stipulated fact, and the reason I read that one is because the Court of Appeals opinion in determining, and the whole limitation of action issue determined by the Court of Appeals was based on the false premise that the association has a statutory cause of action. And the Court of Appeals got there by misconstruing what the statute refers to as a covered claim. For some reason, the Court of Appeals was reading that as if the association has a claim, called a covered claim, to bring for reimbursement. And so therefore they said, well, they've got a statutory cause of action, we'll assign it the 6-year statute. Totally false reading, totally not even considering the text of the statute. Rather, as stipulated by the parties, the covered claim is something that Childers had against American Fellowship, and which the association then assumed responsibility for. The other one is number 8. After assuming responsibility for American Fellowship's covered claims, the association investigated whether PIP benefits were recoverable by claimant Childers from any other insurance policy, since under the governing statute, this is the credit provision, section 7931(3). Under the governing statute, A, Childers is required to exhaust all coverage provided under any other insurance policy. B, any such benefits recoverable by Childers would be a credit against the covered claim payable by the association. And C, to the extent that any benefits actually paid, any benefit payments actually made by the association, Childers is deemed to have assigned to the association any rights he may have against any other insurer for payment of a covered claim. Now, I read that because the credit provision and that assignment provision very clearly show that the rights of the association, both to take a credit and therefore withhold payment because somebody else has to pay it, is dependent on Childers' ability to recover from this other source of coverage, allegedly the Progressive policy. If Childers can't recover from Progressive, then there's no credit. And here, Childers can't recover because Progressive knew nothing about this loss until well after a year beyond the accident, which means no action can be brought under the No-Fault Act.
Isn't the concern that that's going to be the case most of the time? Because for an insurer to become insolvent
Takes time.
and it's only if it happens within this year. So
Sure.
So it would be,
Yep. Why would they-
this instance, under your reading of it, would be the most common application, right? It's the association, it doesn't arise, it's never going to be recoverable by a claimant because they're always going to be, or for the most part, they're always going to be barred by the 1-year back.
Well, not when you're
Or
back.
not 1 year back.
Right,
but
you got it.
After limitations.
Well, that's why I began with the premise that the overarching rule is that the association assumes the responsibility for the payment of the injured person's claim against the insolvent insurer. And it is entirely feasible and understandable that in paying that loss, the association will do so indefinitely, if necessary, such as in this case, an unlimited no-fault claim. It's just, okay, fine, they have to pay the loss. If by chance there is another viable, still existing source of recovery, and it might be another no-fault insurance policy, it could be an uninsured coverage because the association is not only involved in PIP claims, of course, but just broadly speaking, if there's another viable source for the injured person to recover benefits for that loss, then that injured person is required to exhaust those benefits. If he can't exhaust, if there's nothing to exhaust because there's no viable claim anymore, well then fine, it goes back to the default position and the association pays. I don't really know what's so startling about that proposition. And secondly, if the association, which is going to often be the case, will have stepped in and already paid some money, then again, under the reimbursement provision 7935 sub 2, then to the extent of those payments made by the association, the injured person is deemed to have assigned his rights against whatever other source he may have to the association to pursue reimbursement. And again, they use the term deemed to have assigned his rights. Assignment is not defined anywhere in the statute. There's no special meaning given to the term. We know what that term means in the case law and in common law. It means that the assignee has no greater or lesser rights than what the assignor had to give. So under both the credit provision as well as the reimbursement assignment provision, it's clear that the association's ability to take a set-off or to obtain reimbursement is entirely dependent on the injured person's availability of a recoverable claim against another source of benefits. And if there is one, great, those terms apply. If there are, those provisions apply. If there is no other viable source of recovery, even if it was a insurer in the order of priorities, but if that insurer is no longer exposed because it's more than a year has passed since the accident and there's been no notice of any sort given, not that they would give a lower priority insurer notice necessarily, although it happens, then there just is no claim, there is no recoverable claim held by the injured person. And so there's no credit and there's no assignment that has any meaning to it. So those are my arguments on the statute of limitations. The focus on when does the action accrue is, as I argued in the supplemental brief, as I pointed out, the statute of limitations says, provision says, I think I brought it up here, didn't I? Except as otherwise expressly provided, comma, a period of limitations will begin to run when the cause of action accrues. Well, 3145(1) is one of those instances where something, a different time is expressly provided. Here, the trigger moment is the auto accident. A year later, no action can be brought, and that's the one that applies. I want to touch briefly, unless there are questions on that issue, the statute of limitations issue, I want to touch briefly on the coverage issue. As I say, for Childers to have coverage from Progressive, under Progressive's policy, it is entirely dependent on the subsection of the statute. Because certainly there's no connection between Childers and the Progressive policy. The Progressive policy was issued to Matthew Gruels, and there's no connection between that policy and Mr. Childers. So under 3114.4, if Progressive was the insurer of the owner or operator of the vehicle he was occupying, well then Childers can look to Progressive. However, the statute says the insurer of. It doesn't say whether Shayna Gruels was an insured under the policy. It says, was Progressive the insurer of her? And in the Coleman case, that was very closely and carefully looked at, and it says that to be an insurer, the company has to actually extend protection to that person by assuming their risk of loss and compensate them for the loss. And we're talking about Shayna Gruels. And did Progressive do that? No, they didn't. She was uninsured in her car was uninsured, she had no protection whatsoever from Progressive. The Court of Appeals decision looks at, well, it doesn't say insured, but it says, eligible injured person, which for purposes of setting up the policy is the same thing, and it says, well, wait a minute, if she is in a vehicle, one of the requirements is that she be injured to be an eligible injured person. And the Court of Appeals focused on the fact that there's evidence that she was injured, as if that's going to be the difference here. If she's injured, she qualifies as an eligible injured person, and if she wasn't, well then she would not be, and therefore the insurance company would not be her insurer, and Childers would not be protected. That's not what it's about. Because injured or not, she had no coverage from Progressive. She was not going to get benefits if she was injured because she was in her own uninsured car. The fact that if she had been in a different circumstance, let's say if she was a passenger in somebody else's car, she's a resident relative of her brother, then by statute she would have that coverage. But that's not our situation. If an unknown pedestrian gets hit by Matthew Gruel's car under the statute as it existed, that pedestrian would have entitlement to benefits from the Progressive policy. That doesn't make the Progressive that pedestrian's insurer. And as I say, our case law, Daubelaire, makes it clear that just because by operation of the statute you would have entitlement to benefits under a certain circumstance, under a certain policy, does not make that insurer the insurer of that person. And that's, of course, in the briefs, and it's addressed entirely in Coleman. And there is no protection extended to Shayna Gruels by Progressive, and that's the test. So Progressive could not have been her insurer. In the facts of Coleman, I say them down in my 3 minutes, but Coleman, the facts illustrate the rule beautifully. You don't necessarily have to be a named insured in order for that company to be your insurer, but you do have to qualify contractually for protection from that insurer. And the husband, who was not the named insured in Coleman, had contractual protection because it defined you, the named, and you is used throughout, to qualify as the named insured, to be met by the named insured or a spouse of the named insured if residing in the same home. So he was treated essentially as another named insured. But just because somebody, by operation of the priority provisions, might in a certain situation qualify for no-fault benefits, does not make that company the insurer. The trial court got that issue exactly right, and I would commend that opinion to the court. So I've got 2 minutes left, I believe, and I will save it for any rebuttal. Thank you.
Good afternoon. May it please the court, I am Ben Jeffers, and I represent the Michigan Property Casualty Guarantee Association. I'll refer to as MPCGA, or the Guarantee Fund for short. With me at council table is my colleague, Ben Schipper. By agreement with plaintiff's counsel, Mr. Burns, I've reserved approximately 10 minutes, and I'll primarily address the statutory issues concerning accrual and statute of limitations. I anticipate that Mr. Burns will focus more on the specifics of the Progressive policy and coverage under that policy. I want to begin by saying that the insolvency of an insurer is an unwelcome event for everyone. It's disruptive, it's costly, and it can be unsettling in that all stakeholders necessarily need to recognize that the normal payor paradigm has changed. Now, first and foremost is the involvement of the Guarantee Association. Since 1969, when the Guarantee Fund was created by statute, the Guarantee Fund will step in and help ameliorate some of the most significant consequences to an insured faced with the insolvency of their insurer. It's a nonprofit association, and it's here to protect insureds, and to be blunt, not insurers, notwithstanding the fact that the members of the Guarantee Association are all the solvent P&C insurers that write business in the state of Michigan. Importantly, all of the rights and obligations of the Guarantee Fund arise out of its enabling statute. And for decades, the MPCGA has fulfilled its statutory role in a consistent way, working with insureds to do, as Mr. Saylor said, to day in and day out pay claims of the insolvent insurer. But we've also operated in a consistent manner in our interactions with other stakeholders, other insurers, even the court system, with 6-month stays involved. There are changes in the event of an insolvency, and we're very proud of the fact that, quite frankly, we often fly under the radar. I think we can all
So
agree.
what statute allows you to bring a claim against Progressive?
Thank you, Justice. As I said, all of our rights are under the Guarantee Fund statute. And first and foremost, we've got to understand that there are two main limits of our obligations under the statute. One is 7925, which defines covered claims, which Progressive's counsel talked about. Then you have 7931, which contains the credit provision. These are acknowledging that the Childers claim may have been a covered claim is not an admission that there's no credit. Quite to the contrary. You start with, is there a covered claim? And then you look to, even if there's a covered claim, is there other available insurance? So, to answer your question, there necessarily must be a cause of action that the Guarantee Fund can bring. Otherwise, its rights to take a credit would be superfluous.
Is the claim that you make on your own merits, are you stepping in the shoes of the insolvent insurer, or are you stepping in the shoes of the plaintiff? I'm having a hard time understanding the source of and the scope of the claim.
Right. The source would be 7931.3, which is a statutory provision dealing with a credit saying that the Guarantee Association is entitled to a credit if damages or benefits are available to the claimant. So there is that duality where we have to look at whether the claimant itself, whether there is other coverage out there, right? The Guarantee Fund, later in that section, it explicitly talks about how the operation of the credit provision can serve to reduce the Guarantee Fund's liability. So what we're really talking about is, should someone else be paying? And the statute recognizes that if there's other available coverage, the Guarantee Fund shouldn't have to pay. So what happens, Your Honor, if we have started to pay and we have found other available insurance and they don't want to do it? Under 7911, the Guarantee Fund has a very broad set of rights that allows the Guarantee Association to pursue its rights in court. Okay? There's no point in having rights to reduce your exposure under the credit provision if you can't enforce those. The claimant, likewise, has rights under the credit provision. The claimant has, in fact, an obligation to look for other available insurance, and by definition has to have the opportunity to fulfill that duty by pursuing Progressive. And so it's really both the claimant and the Guarantee Association, standing separately, but in a sense aligned, have the right to look for and avail themselves of other insurance.
Can I ask you, so a couple of times you've mentioned or you referred to it as if the claimant has other benefits available. Mm-hmm. The statute doesn't say available. The statute says if those benefits are recoverable. Mm-hmm. And so while the Guarantee Act is not subject to other provisions of the No Fault Act and it's a claim arising under the Guarantee Act, what are we to do with the fact that the language of the statute, the Guarantee Act, tied it to the claimant's ability to recover benefits under no fault?
Right. No, great question. You're right. It starts off by talking about benefits that are recoverable. Further in that section, it talks about the claimant needing to exhaust coverage. So I think this is really a coverage question. What you're really asking is there other insurance in terms of coverage, whereas Section 3145, which they're relying on, is a temporal issue. That's a timing issue. That's
Well,
not
if
whether...
your claim is, if you're can't collect benefits because you're outside the 1 year of statute of limitations, do you have coverage?
Yes. So in this particular case, the third issue that the court wanted to consider was whether or not there is coverage under the specific Progressive policy. And we would acknowledge you could have a scenario where we're eligible to look for other insurance outside of the 1 year, but you may look at that policy, you may look at the Progressive policy and conclude, well, it actually doesn't afford coverage here in this instance. So we're not saying that we're like the assigned claims facility where just you randomly find another insurer and they're on the hook. That insurer, for something to be recoverable, there has to be another insurer out there that has a real-world connection to the incident giving rise to the claim, and they've got a policy that covers someone involved in that incident such that they would be in the order of priority. Now, the reason we believe that 3145 and the 1 year statute of limitations does not render that unrecoverable is one question you raised earlier, which is, well, it's going to be the rare case that we could ever avail ourselves of this right if 3145 is applied. But more importantly, Your Honor, we've got case law and the statute, the plain text of the statute itself. 3145 relates to claims under the No-Fault Act. The Guarantee Fund is not bringing a claim under the No-Fault Act. It's bringing a claim based upon rights it has under the statute. And as those rights are going to be manifest in sort of two ways. One, and one is aligned with the claimant and one is a little different. If someone has coverage, it's available like Progressive, well, we're entitled to ask a court to rule that they have to pick up the claim on a going forward basis, right? That's not a claim that the Guarantee Fund is making for benefits under the No-Fault Act. That's seeking a legal determination that someone else has priority, someone else is responsible. Now, if the Guarantee Fund starts to pick up the claim like they did here and is spending money paying providers, and it's ultimately determined that Progressive should have been the one to do so, well, it is only logical that the Guarantee Fund can recoup those monies. Those are monies that would come back to the Guarantee Fund, right? That's why it's not a claim for benefits under the no-fault statute, because the Guarantee Fund is seeking recovery of monies that it shouldn't have had to pay, given the existence of other insurance. I will move on very quickly. There's a couple, I think, logical flaws with Progressive's position that 3145 provides a temporal limit on the Guarantee Fund. One I just mentioned, that we're not bringing our claim under the No-Fault Act. Two, I think inherent in their argument, and certainly in the briefing, is this concept that the 1 year statute of limitations represents this just overwhelming legislative intent to make sure that insurers don't have to deal with PIP claims after a year. Yet, what we see is there's all kinds of instances where PIP claims are dealt with, disputes over PIP claims are dealt with outside of that 1 year. Insurers that are both in equal footing, equal priority, can sue each other for recovery within 6 years. You have thank you, Ben. You have the assigned claims facility that has 2 years to seek reimbursement. Under the Cooper v. Auto Club case, if you happen to have a fraud claim relating to PIP, you've got 3 years. So the point is, we don't have this overarching legislative policy where insurers have been given this legislative mandate or grant that they could never have to deal with a claim after 1 year. Two, I think that the conversation about a claim, and I'll try to end with this because I know my time is running, it's based a bit on a misconception of what we're really talking about. Because you have this theme that it's too stale. We didn't learn about this for a year later. By the time that a company in Progressive's shoes is being asked to pick up the claim, A claim has already been lodged with American Fellowship. A claim's been preserved. There's a claim file. American Fellowship was handling it, and then the Guarantee Fund was handling it. So what we're really talking about here is not the existence of a new claim out of the blue, but shipping the claim file over to Progressive. So we don't have a concern about staleness. This isn't someone coming out of the blue and saying, I've got a personal injury that I think now relates back to an auto accident I had 4 years ago, and I get a new green light to pursue that. It's not stale at all.
So if the paying insurer does not go insolvent for 20 years, we're paying benefits for 20 years, 25 years, you still get time when the insolvency hits to go back and try to find a lower priority insurer 25 years earlier and say, hey, you're on the hook.
I think the legislature in setting forth the credit provision and giving the guarantee fund rights to limit its exposure, I think that's a potential outcome, Your Honor. I understand that that's sort of an extreme set of facts. Those aren't our facts here.
No, I know. We don't decide just your case. If we make this ruling, if that were to occur, are we saying there is no limit, 10, 20, 30 years, whatever it is, the lower priority insurer could still be on the hook?
Conceptually, yes. Conceptually, yes, as long as we, there is still a time limit that's going to be involved for the Guarantee Association to pursue that claim. So it's not unlimited. It's not going to go forward into the future forever. We are saying that once the Guarantee Fund is triggered and has its statutory rights, including to look for other insurance, that could go back a ways for sure. But the Guarantee Fund nonetheless must do that at minimum within 6 years, which would be the default statute of limitations, to pursue its rights.
Okay.
Thank you, Your Honor.
May it please the Court. Richard Burns appearing on behalf of Susan Childers as the conservator of the estate of Justin Childers. Addressing the third issue, whether the appellant is an insurer in the chain of priority of insurers, I would like to preface my comments that when a no-fault insurance company becomes insolvent, the responsibility for paying benefits owed under the policies issued by that insolvent insurer is transferred to the Guarantee Association or to the insurer in the next order of priority under, in this case, 500.3114. Accordingly, in the event the insurer responsible for paying lifetime PIP benefits becomes insolvent, legacy claimants such as Justin Childers drawing benefits from that insurer must be able to claim lifetime benefits from the Guarantee Association or the lower priority insurer, in this case, Progressive. Progressive.
I don't understand why you're standing here. You're going to be covered no matter how we decide the case.
Your Honor, I am following the mandates of the Guarantee Association Act, where I am required to pursue a lower priority insurer that's been identified, and I am complying with the requirements of the Guarantee Act.
But you're going to go home tonight, and you know that no matter what happens, your client is going to have coverage, correct? I just want to make sure I understand it properly.
I would hope so, Your Honor.
Yes, okay.
Progressive is in the chain of priority insurers because its policy contractually expands the definition of who is an insurer. Progressive, of its own volition, has put itself in the chain of priority by the terms of its policy. Shana Groulet is an eligible injured person who is a relative of Matthew Groulet, who sustained bodily injury in an accident involving a motor vehicle. Because of that, she is an insured contractually, and then we must look at the two-step process of determining coverage. Now, the Progressive cites the case of Hunt versus Drelick, which explains that we employ a two-part analysis in determining the party's intent as to insurance coverage. First, we must determine whether the policy provides for coverage to the insured. And then second, the court must ascertain whether the coverage is negated by an exclusion. In this case, under 3114-4, we look first to the question, is there coverage for, in this case, Shayna Goulet? And at that point, the inquiry stops, because the 3114 is both an entitlement and a priority statute. And in this case, Progressive has ignored the two-step process that is necessary to determine whether Shayna Goulet is a contractual insured. The fact that she may be disqualified from coverage does not alter the fact that she is a contractual insured by the Progressive policy terms. Progressive's argument would be correct if 3114-4 were rewritten to say the insurer providing coverage to the owner or registrant of the vehicle occupied, but it does not. Now, one of the points also made by Progressive in its briefing was that the Court of Appeals opinion never comes to terms with the actual definition of insurer, taking the position that a policy merely utilizes the utilization of the term insured or eligible injured person renders the issuer of the policy the insurer of anyone so identified. Now, the Court of Appeals cited Stone versus Auto Owners, where in analyzing both Dobler and Amager versus Coleman, stated the named insurer may also constitute the insurer of the owner or operator under 531.14.4 if the policy expands the definition of insured beyond the named insured, so as to include those persons, which in this case is Shayna Goulet. Whether the insurer policy is the insurer of a household member or family member for the purposes of 3114.4 depends upon the language. Here, it's clear that Shayna Goulet is a contractual insured, and thus, under the terms of the 3114, Justin Childers may look to Progressive for its coverage. Thank you.
Your Honors, just very briefly, Mr. Jeffers, on behalf of the association, insisted that the association's not bringing a claim under the No-Fault Act. So I wonder what claim they're bringing then, because there was no attempt to defend the Court of Appeals' notion that it had a statutory cause of action under the Association, the Guarantee Act, on this, vague reference to what covered claim means. There was no attempt to defend that. And so the only provision that allows them to bring a cause of action is the fact that it is an assigned claim from Childers. And Childers clearly would have no action against Progressive other than one under the No-Fault Act. So so it is an action brought under the No-Fault Act.
I have a question, and it may sound sort of silly, but if we agree with you that, that the ability for the setup under the Guarantee Act or the credit is dependent upon the insured's ability to recover from another priority insurer, and 3145 requires that. If, say in this case, Childers had provided notice within a year of the accident to Progressive, and maybe going forward, if you're correct, you provide notice to every insurer out there within a year of the accident, then in the event that your insurer goes insolvent, you're not going to run into this problem. You're not going to be barred by 3145. If
No,
you've
then
given
you'd
notice.
only have a one-year back.
You'd have a 1 year back, but presumably you're getting those benefits paid by the insolvent insurer, so maybe you're not going to actually run into a gap of coverage. But so is sort of, if you're correct, and if we agree with you, is the sort of standard practice going forward, should it be that any plaintiff's attorney needs to provide notice of the accident to every possible insurer that could be drawn in by MPCGA?
No, because as Justice Zara pointed out, the injured person and that injured person's attorney don't have to worry about that. The injured person's protected. If they want to be altruistic to the association and do that, so that down the road, if by chance their insurer becomes insolvent, well, then I suppose they could do that, but it would be, I don't think that's going to happen, and I don't think that there's any purpose on behalf of the injured person to do that. They have their protection. So it's kind of a fictitious, hypothetical, if you will.
I did say it was probably silly. So
Okay,
that's
well, I don't know about that. And I
And
know my
counsel,
time is up.
to be fair. Yeah.
Counsel, I think we would acknowledge that obviously insolvency, thankfully doesn't happen a lot, but there's a pathway that they're supposed to have, for the claim through the Guarantee Association. Why would the legislature create a pathway that is essentially unusable? I mean, is it ever usable for an insolvent? Because I just don't think, obviously the odds of this coming up within the first year are pretty slim.
Maybe,
I mean, I
maybe
guess it
not.
could happen.
Like I
Doesn't
say,
this
it's
apply,
not
doesn't
just
this apply to more than just no fault?
That's what I'm saying. It's not, this case happens to be a no-fault case, which has the one-year statute and everything, but it's a broad provision, which is sort of, number one, the Guarantee Association pays the loss in the place of the insolvent insurer. That's the big picture. Now, if by chance there are other benefits still recoverable for this loss by the injured person, well then it makes sense to allow the association to take a credit for those benefits and to require that individual to exhaust those available benefits. And likewise, if they've paid money, to be able to pursue recovery by assignment for those available benefits. There's nothing shocking about that. The fact that it may not come into play oftentimes, because oftentimes a lot of time will go by before you ever get to that point, I don't think is either here nor there. It's just, if it's available, then the recovery and the credit is available.
So are you saying that there's a certain period of time that it becomes unavailable?
Unavailable by reason of the underlying limitations in that injured person's ability to recover from another source, whether it's statute of limitations or whatever reason that benefits are not recoverable by the injured person, which is what the credit provision specifically says. If, it starts off, if benefits are recoverable by the injured claimant or the claimant, ... and it goes from there.
Thank you. I don't see any other questions. Thank you very much. The case.
Thank
will be
you very
submitted.
much.